Hello friends, I am CA Rohit Garg. Today we are going to discuss the judgment and we can say this is the BAP of all the judgment. Why I am saying so you will know after watching this video. Friends, the reassessment proceeding which is re-amended by the Finance Act 2021 has two parts. One is section 148 proceeding and after 148 proceeding the reassessment proceeding. What is going on today, what is the practice which is going on in the department today, the 148 proceeding in which the show cause notice issued to the assessee and after considering the reply of the assessee, the department initiate reassessment proceeding and after initiating reassessment proceeding issue notice under section 148 and transfer the proceeding to the faceless assessment section under section 144B. Now, what is the contention of the assessee in this petition? The assessee in this petition challenged these practice of the department, which is under section 148A and which is handled by the judicial assessing officer. Now, the contention of the petitioner is that these proceeding under section 148A also should be handled by the faceless assessment center and the faceless assessment scheme which was introduced after the Finance Act 2021 in March 2022 should be followed by the department. So there are so many petition has been filed on the same issue. And friend, one more thing I want to clear here that the fact of the case is that in all this proceeding, the reassessment proceeding reinitiated by the department after the Supreme Court judgment in Ashish Agarwal case. And the assessee said here कि after the Supreme Court held that all these cases, which is about 90,000, should be handled by the department are subjected to the new act which are introduced by the Finance Act 2021. And the contention of the assessee is that faceless scheme should also be applicable on these proceedings. So friends, the question which has been primarily raised before the High Court is that whether the impunged order under section 148D as well as the notice under section 140 of the Act could be issued by the local judicial assessing officer rather than the faceless assessment. Means ki there is proceeding which is reinitiated after Supreme Court judgment should not be handled, should not be held by the judicial assessing officer, they should be handled in the faceless manner. Now, the counsel of the assessee refer the CBDT judgment which is dated on 29 March 2022 in which he prescribed the procedure of faceless scheme and in this scheme he said कि for 147 proceeding and 148 proceedings shall be initiated through automated location. Automated location means कि there is no concept of judicial assessing officer. The cases refer on the automatic allocation basis without considering the judicial assessing officer. But what is done in these cases? All these cases initiation has been done by the judicial assessing officer. Now the department the department counsel say कि all these cases are open in the new old law and new law should not be applicable there. And now there is argument also there कि there is no difference between the judicial assessing officer, faceless assessment center. They have the concrete jurisdiction, so anybody can handle the proceeding. But their whole argument does not by the court and held invalid. So in this, I also told that these are cases which is in which the notice initially issued after 1st April 2021 and between 30th June 2021, and these cases referred held invalid by the different High Court. Then the matter go to the Supreme Court and the leading judgment is the Ashish Agarwal case. We have all discussed all these things in our previous video. You can refer. Now the main argument of the department held invalid by the court by referring this Supreme Court judgment, because this Supreme Court judgment clearly said कि these proceeding यानी कि these cases should be subjected to the new law, and if these cases are subjected to the new law, the section 144B, which is make mandatory the faceless assessment, is also applicable on these cases, which is not followed by the department. Now the court discussed the various schemes, the law of the faceless which is passed by the parliament, different faceless schemes, board notification, and in all these notices, in all these notification, in all this law, it is held that ki all the assessment proceeding under section 148A, 147, 148A should be in faceless manner. After considering all this fact, the court held that after the introduction of the above two scheme, it is become mandatory for the revenue to conduct initiate proceeding pertaining to reassessment under section 147, 148, 148A of the Act in the faceless manner. And as the department does not follow faceless scheme for 148A proceeding, 148 proceeding has held by the local judicial assessing officer, and it is the violation of the law, which is a serious violation of the procedural lapse on the part of the department in all, and all these cases held quash. Friends, as we have discussed, these judgments are related to the cases which are reopened after the Ashish Agarwal case, Supreme Court, but it doesn't mean कि all the proceeding, rather मतलब all the proceeding except this proceeding, this judgment cannot be referred. The crux of the judgment is that कि 148A proceeding after March 2022 should be in the faceless manner. So friends, all other cases in which the department initiate 148 cases through judicial assessing officer are invalid if we consider this judgment. Now friends, after these after reading this judgment, I also find to search ki some other cases also filed in the High Court. So friends, we find two more cases, one in the Andhra High Court and other in the Rajasthan High Court, Jaipur bench, in which also same contention has been raised by the assessee and also the judgment. So friends, if you like my video, you can subscribe my channel and motivate me to make such another video which is maybe useful for you. Thank you.